Hello everyone, welcome to our channel Ivy Legal. In our today's video, we are going to talk about section 122 of Indian Evidence Act. This section basically talks about all the communications which takes place between a husband or wife or between two spouses during a marriage. Mind my words, there is only two words which plays importance under this section. The very first is that there need to be two spouses, and the second is there has to be some communication between the spouses. The third important word is that those communication between the spouses should have taken place during the marriage. If these three conditions are satisfied, then the spouses are prevented from disclosing such communication. They can neither be compelled nor be permitted to disclose such communication which has taken place during the marriage. So this was done basically to ensure the sacrament confidentiality between two parties who are married and between two spouses. So basically, in order to foster the concept of trust and confidence between the parties, between two spouses, this concept of communication during marriage to be kept confidential was brought in by section 122. But does that mean that in all the cases this communication cannot be disclosed? Are there any exceptions to the same? Yes, there are an exceptions under section 122, in which cases the communication, even if during the marriage, can be disclosed. So exceptions are as follows. The very first exception is, moving on to the first exception, the first exception is acts apart from communication. That means those acts which are apart from communication. Suppose husband has exercised any violence on wife, so this is basically an act which is different from communication. So this act can be disclosed by wife before the court. So acts taken place between two spouses can be disclosed. But now uh, you can also assume that if suppose while performing any acts there is some sort of communication taken place between two parties, then will that communication form the part of this exception? No. The communication forming the part of any action or any conduct will not be disclosed. Only the part of action or conduct can be disclosed by the spouses and not the part of communication. So the communication part still remains privileged. Only the acts and conducts can be disclosed. Moving on to second exception, that is waiver of privilege. Waiver of privilege is as simple as that, because if any party has a privilege and if party himself expressly confers that he waives off his privilege, then in that case the express consent has been obtained, and there remains no confidentiality and the communication can be disclosed. So in case of two spouses, if one spouse expressly waives off her privilege, his or her privilege, then in that case the other party can disclose the communication made with the other party. So that is all about waiver of privilege. Moving on to third exception, that is suit or criminal proceeding between two spouses. Now remember one thing, if whenever there is a criminal suit between two parties, between two spouses, or a suit between two parties or two spouses, then in that case the communication becomes important, because that is the essence of, that might be the essence of criminal proceeding or a suit. So that communication can be disclosed against each other, as we have discussed under section 121, that these husband and wife are treated as separate parties. So therefore they can be a witness against each other, and hence they can disclose the communication taken place during the marriage only in the cases when there is a criminal proceeding or suit between two spouses. So this was the third exception. Now moving on to fourth exception, that is communication made before marriage or after dissolution. So this is pretty simple and fair. That is, if any communication is taken place before marriage or after dissolution, both can be disclosed, because the privilege is only given to the communication that has taken place during the marriage. Now coming on to fifth exception, that is proof of communication by third person. So this is very important. See, whenever communication takes place between two spouses and if third person overheard the communication, then in that case you can't stop the third person from disclosing the communication, because he is not the party, he is not the spouse. So this section only restricts to spouses, right? And this section only restricts to the communication taken place between the spouses during the marriage. There is nowhere mentioned about third person. So if a third person overhears the communication taken place between two spouses during marriage, the third person will not be prevented from disclosing the communication of two spouses. He can be a competent witness against those spouses. So this is so because privilege under section 122 is to parties to marriage and not to the third parties. Then an important case under this section is MC Varghese versus TJ Poonam. In this case, it was held that even if one spouse is willing to disclose the communication, he or she will not be permitted unless express consent is obtained from the other spouse. So that requirement has to be satisfied before disclosing the communication that has taken place during the marriage between the two spouses. This was all about this section. मिलेंगे अगली वीडियो में जहां बात करेंगे कुछ और टॉपिक्स के बारे में ऑफ एविडेंस एक्ट. आपको वीडियो पसंद आई है देन डू लाइक एंड सब्सक्राइब आवर चैनल, हिट द बेल आइकन फॉर रेगुलर अपडेट्स. थैंक यू.